So in case you didn't come to the panel this morning, I'm Jake Krasnov. I also go by Hubble, is my handle online, and that was my call sign in the Air Force. So my background's like red teams and kind of compliance frameworks. I also do a lot of operational technology, security stuff. So I initially was an aerospace engineer for the Air Force, and while I was in, got converted to cyber. I showed up to work one day, and they're like, "Hey, Congress said that we have to do cybersecurity testing for all weapon systems," and I was working on airplanes at the time. Specifically, I was there for like the missile testing, since I had that was what my degree was in. I walked in, they're like, "Yeah, Congress said all the airplanes have to go through cyber testing. You're our new cyber person." So that's how I got into the world of cybersecurity. And so I ran the first pen test of the F-22, planned like some stuff against the F-35. And then after that, went to Boeing, where I was doing, where a lot of my compliance work came in for Boeing, doing NIST framework stuff, as well as helping on some response stuff that involved SEC. And then when I started BC Security, we started while I was still working at Boeing. My dad was the chief compliance officer at a financial advisement company, and so I did some work with them to help them, and he also got me spun up on some of the SEC compliance stuff. And so that's kind of just a quick history of my background. I've done tons of stuff on operational technologies. If anyone has questions after that, like aircraft, autonomous boats, all that kind of stuff. So just as like a quick overview, we're going to do an overview of like the SEC guidance and we're going to step through it as a timeline so that we can kind of see how the SEC's changed their enforcement, and as well as like hasn't changed it, because there's been formalization of the SEC rules, which we'll talk a little more about. Of like the SEC actually doesn't like rules. Everything's technically guidance in SEC, with the exception of a handful of things. And so we'll go through that along with some case studies of how they've been applying stuff to various companies. We'll go through like a quick breach scenario. The breach scenario will actually be more fun with a smaller group, because you guys can actually give me some feedback. And then we'll do like concerns versus those, and accountability, and like the way forward. So the most important word when you're dealing with the SEC is this word called material. If you go read SEC guidance, everything that they say, even whether or not it's cybersecurity or not, when they're like something has to be disclosed due to risk to the company or anything like that, it will always say a material risk. And material has kind of a subjective definition, which is it's something that would cause a quote-unquote reasonable investor to change their risk assessment of the company. So what you consider material is kind of, like I said, is a subjective measure, but what it's supposed to mean is like if I was raising money and someone wanted to invest in my company, and I told them, I'm going to start making cars, like, start a car assembly line, and I represented it as having my own like manufacturing assembly line or something like that. And then I came in and told them, actually, I don't have the assembly line yet. We're gonna be building that. That would change someone's opinion on whether or not they want to invest in the company. So that's kind of what they mean by material for risk. It gets fuzzier with cybersecurity, because we'll talk about it. You have to report anything right now that's considered a material cyber event, and it's supposed to be tied to that reasonable investor. And it gets a little complicated, because even just having like a news headline about your company being breached or something can cause investors to rethink about whether or not they want to invest in you, because of the reputational risk that's ongoing. But that means you have a little bit of a chicken and egg of like, if someone made a simple breach, like incursion into your network, and all it was someone clicked a phishing link and it ran on that single computer, I don't think any security experts would consider that like a material event. But if someone made a big headline about, your company got hacked, that could change people's opinions, and then you get into kind of a debate with the SEC. And so it maintains a little bit of fuzziness. They've been doing better on what they consider material, but anytime you talk about the SEC, you have to remember that word material, and then you have to remember that the SEC, outside of a handful of things, doesn't actually have rules. They have guidance, and its interpretation. It's tied a little bit to the fact of You may have seen it in the news last year because there was a big Supreme Court case of what's called Chevron theory, of where where Congress can delegate their ability to legislate. It's not really their legislation, but their ability to enforce rules to agencies. So the SEC doesn't have the authority to make a law or a rule that someone can be like strictly adhered to, measured against, but they do have the ability to enforce the guidance that that Congress has passed. That's where Sarbanes-Oxley comes in. That's where a lot of the basis for where a lot of the SEC rules comes from, as well as some of the laws that were passed after the Great Depression, like the 1930s and stuff. A lot of that is, we'll see, they actually based some of their cybersecurity enforcement in the mid 2010s based on like 1930s laws on like risk disclosure. And so this creates ambiguity, especially for smaller companies. So like large publicly traded companies, this is less of a problem for. Where this gets really hard for compliance is if you're like a smaller financial advisement company. Because if you're a registered financial entity is anyone that handles customers' money like directly. So not like someone like a payment system, but like if someone's giving you money to invest. So if you're like a one-person financial advisor shop, you are a registered financial entity and you have the full weight of the SEC compliance, even though you're a single person, versus like Google having to comply as a publicly traded company with SEC guidance. You know, they have a whole army of lawyers that can help them figure this out. So the other place where it gets a little weird that we'll talk about is guidance spillover to contractors and suppliers, because the SEC has started holding companies liable for compliance failures of their suppliers and contractors. So we'll talk about that. There was one company, one of the case studies is a company where basically the SEC said they had adequate security compliance for the company itself, but they didn't apply enough security controls to contractors. And so that now spills over into companies that may not have SEC guidance directly applied to them, but may have to comply because their customer is working for it. So the beginning was 2011. Up until 2011, the SEC had no guidance on cybersecurity, whether that was explicit rules or guiding documentation. There was technically some level of, as they interpreted this and they published, basically they say like disclosure, risk disclosure requirements that had existed since the 1930s mandated that cybersecurity be treated under that. And so because cybersecurity is a material risk. But up until this, there was no actual strict guidance on what was being considered reportable for cybersecurity. So the big thing about it was it required disclosure of cybersecurity if a material cyber event happened. So it just said that you had to disclose it. There was no time frame, nothing associated with it. But it did say you had to disclose it, and then you only had to disclose cyber risk if it was among the most significant factors of risk in your company. And it will probably be no one's surprise. Basically, no one said that cybersecurity was a top risk in their company, so they didn't disclose anything. So it had no discussion of cybersecurity policies. So it only had a requirement to disclose if cybersecurity, like the risk of a breach or something, was among your top risks, or you had an incident that had to be disclosed because it was a material incident. But they did mention that you should disclose if you had cybersecurity insurance, which was a weird kind of caveat in there. They weren't the first government agency to start enforcing cybersecurity. They were actually kind of late to the game a little bit. But the first kind of recordable instance of the SEC actually enforcing a fine against someone for failure of cybersecurity policies was Yahoo, or at the time they were Altaba. They had a data breach that they incurred in 2013 to 2014 that exposed 300 million users, passwords and emails and all that kind of stuff, and they didn't disclose it until Verizon tried to buy them 2 years later in 2016. And so this was the first time they got hit with a $35 million fine. And so this was the first time that the SEC actually said, hey, no, the fact that you lost 300 million customers' data is that goes back to that material. That's a material event. You have to disclose that, and it applies to you. So this part of it, of disclosure failure of breaches, this hasn't really changed. Like the SEC's philosophy on how this applies to companies hasn't really changed since 2011. They've gotten more aggressive in their enforcement, so it's something for us to keep in mind. But they didn't actually, this hasn't changed. This has all been the same. Like basically they've, since 2011, 2018 technically, the court case started a little earlier. They haven't changed that like a failure to disclose is an SEC violation and they will fine you for doing that. The second one, which happened the actual court case happened about a month later, was Voya Financial Advisors. So these are the registered financial entities, fell victim to a social engineering attack. And this one's actually different and kind of interesting because if you like go Google, like most places that tell you about the history of SEC cybersecurity won't actually discuss this. They'll mention that Yahoo one, but they won't talk about this one as the first time that a company was prosecuted for failure of like policy, not a failure of disclosure. Because Voya did disclose that they had been hacked. Like they didn't hide it. Like Yahoo, spent 2 years and didn't disclose it. Voya actually disclosed to their customers that this happened, but the SEC came in and analyzed what happened and said they didn't have adequate security controls in place. And this was to their contractors. So this goes all the way, like when you look up when was the first time the SEC, like you just go Google it, when was the first time the SEC enforced like a fine for like policy failure rather than disclosure failure, you'll get one from like SolarWinds, like which was in 2023. And that's not really true. Like they've actually been enforcing this for a while. So it's just kind of, highlights, and again, it goes back to this identity theft red flags rule, and it was because they hadn't updated any of their policies for dealing with social engineering and identity theft since 2009. But this rule was from like the 80s, and then the other rule that I think I had on the other slide, this safeguards rule is from like the 50s or something. Like that's a really old rule. It basically says you have to protect customer data. Like you can't just like, take everyone's social security numbers and like post them on the front wall. Like it's a really old law about just protecting like sensitive data, which kind of cybersecurity related, but wasn't cybersecurity specific. It was just PII, like from the actually that might have been 1980s rule, but yeah, customer PII laws is what it happened under. So this was actually the first time that the SEC hit someone for failure of policy and not a failure of disclosure. So in 2018, after all these cases that they won, we had this kind of reinforcement of their interpretation. So they didn't release any formal rules. That doesn't happen until 2023. But they released a document. Oh, actually, sorry. Before we go back, I don't have slides for it, but I want to talk about it. During this time frame, the FTC also sued Uber. Does anyone know what Uber got sued for or remember? It's from 2014 timeframe. So they had their public key or their private keys stored in their GitHub account, and someone hacked them. And so their CISO actually went to jail for it because they instead of disclosing it, they tried to retroactively pay the hackers and claim it was a bug bounty. Even though the hackers had stolen all the data and taken it offline and done stuff, Uber tried to structure it after the fact as a bug bounty, and the CISO went to jail for that. Well, not jail. I think he just had to pay a fine and then like probation was what they tried to send him to jail, but he was convicted. So that was the FTC case was kind of the first time that a CISO was held responsible for a hack, like personally. And it won't be until 2023 with the SolarWinds that we'll see the SEC go after that. But it is like something to keep in mind when you're doing this compliance stuff that like transparency is the best policy for most of this stuff. The reason that the CISO at Uber tried to cover it up was because they had been hacked in so it's 2014 and 2016. Yeah, 2014 and 2016. They'd been hacked in 2014, had just settled a case with the FTC for paying a fine for not properly securing stuff, and then got hacked the exact same way in 2016. And so they tried to cover up the 2016 breach, but with that bug bounty program. And so, because they didn't want to pay fines again and like have the public relations problems that it would incur. And so generally from a, like if we're CISOs or just kind of people in directors, like the decision-making process tree, as long as you make a good faith effort to disclose and to protect information, you're generally safe from being like personally gone after by the government. There hasn't been a case yet where they've won something that like they could show that the person made a good faith effort. But in 2018, they updated this. Probably the most interesting thing from the 2018 changes is this last line. Up until 2018, no one had considered insider trading on cyber breaches. So like if you were a person that knew, like on the security team, that found out that like Boeing got hacked and you went and traded on that information before it was disclosed to the public, the SEC actually hadn't written any rules on that being considered insider trading because it was not considered like under their definitions material information up until that point. So the 2018 guidance actually explicitly came out and said, hey, trading on this information is insider trading and we will prosecute you for it. The other thing was it also emphasized that the companies had to disclose cyber incidences. This was them coming out and being like, okay, guys, we know we said that like you only have to do it if it's among your top risks. Well, you can't just arbitrarily say it's not a top risk anymore and like consider it okay. So this is kind of the in terms of disclosure policies, other than some like hard timelines that they add in 2023. So, which stealing my thunder a little bit, in 2023 they added that you have to disclose within 4 days of determining that there's a material breach. That there has to be a filing. Other than adding that 4-day timeline, this is kind of the last rule that they add in terms of disclosure requirements. And so it also explicitly informed companies to consider the probability of occurrence. So the guidance in 2011 had told them only to disclose an incident that had occurred. It didn't give guidance that you had to consider what your risks were of it actually happening. And so they also explicitly said that. So our case study 3 is our Pearson PLC. So this is the book company. Like I'm sure that's like everyone's favorite company if you went through college and had to pay for their books. Oh, I have a typo on my slides. So in 2018, Pearson experienced a data breach that exposed 13,000 accounts. They got in trouble here because in 2019 they had a report. They reported that they experienced a hypothetical risk of a breach, even though they knew for a fact that they had a breach. And so the breach was like they got fined like $1 million, I think, for this one. The other thing that made this case a little more interesting was that they made public media statements to the that said that like customer data may have been exposed when they had internal communications confirming that customer data had been stolen. And that was explicitly used by the SEC as reasoning for them being misleading in their disclosures. And so the SEC, since this case, will use media statements as like evidence that you didn't properly disclose stuff. And this is really important because this is where one of the places that like CISOs and stuff will get in trouble in their organization, because the public relations people and the lawyers, especially lawyers that aren't well versed in SEC stuff, are never going to want to admit that you actually lost customer data because of the public relations problems. And so there's a lot of tension here in what a company will want to say from a public relations standpoint to what you should actually disclose under SEC guidance. Because they're going to want to deny for as long as possible to protect the reputation of the company. And so this is something that you really need to have like discussions and meetings with prior to an incident inside the company to have a policy and a plan on how you'll coordinate that, because the SEC will really aggressively use statements if they can tie like any kind of email in their investigation from inside the company of someone saying like they knew for a fact that something had happened when you made a statement about May, even if you're like, well, that person stated it as fact, but we hadn't completed our investigation, so we said may. Like the SEC will be like, you guys had emails saying that you knew. So that's one area of like major concern, and one of the kind of most interesting updates from this. So you'll definitely want to like talk about that a little more. So in 2019, this is another interesting one. The first American financial corporation got contacted by a tech journalist who had found I think it was like a directory traversal or something. It was a serious cyber vulnerability, but a relatively trivial one to fix. So they called the company. The company sent that up to their directors and everything, and everyone fixed it. And they did everything they were supposed to within 4 days of notification. It was actually the business day after the first business day after the article that the tech journalist wrote went public. They filed their Form K-8 like they were supposed to. And they hadn't had a breach yet. This is one of the major things from this one is a breach didn't actually occur, from what I remember. But unknown to the executives, the security staff at the company had known for months about the vulnerability, and it hadn't been fixed. And the SEC fined them. It wasn't a lot. I think they fined them $43,000 or something, which for a big financial company, not a lot of money. They said that it doesn't matter that your executives didn't know. So they basically said what really changed here was that they said that the reason for the fine was not their failure to disclose or their security control policies. It was their failure of having a system in place for the security team to be able to make directors and board members aware of the problem. And so it was a really kind of firm stance by the SEC to say hey, you can't claim a lack of knowledge as a reason why you didn't disclose. And if someone inside the company knew, then you should have a way of elevating that and be able to tell us about it. And so this changed a lot of things in terms of how people treated what they need to write into their cybersecurity policies, and that kind of stuff. And as well as kind of, if you've ever ran a tabletop, this is probably a part of that. How do you inform the decision makers on that should be a part of your tabletops, and is all kind of stemming from this 2019 case of the SEC being we don't care that you said you reported when you were informed about it. People in the company knew, so you should have known because you're in charge of the company. And so that had a profound effect on a lot of the cybersecurity disclosure stuff. And then we get to 2022. That's when they released proposed rules. Specifically, they released some additional proposed rules for registered financial entities. There were going to be a bunch of additional things that registered financial entities had to comply with, and that was going to be a good part of my talk. But a week and a half ago, they scrapped all the pending rules for this, so it's no longer relevant. But they were going to require they still pseudo do. You now have this annual disclosure of cybersecurity risk management strategy and governance. So your GRC now has to be a part of your annual disclosures under the SEC, the 2023 SEC guidance. Part of this thing is disclosing your programs, and they are evaluating what is a reasonable program to have. And so under programs, there's some discussion about how much testing actually has to be done for a company. And so again, for someone like Google, you're going to be paying for pen tests and that kind of stuff anyway. But if you're a registered financial entity that has to comply with this, and you're a 4-person financial advisement company that's making, $400,000 a year or $500,000 a year, the idea of having to pay for a red team to come in every year and run a test is not really something you can afford. And so right now, because of this, there's a lot of ambiguity on what are the actual testing and assessment requirements. So I personally think that for smaller companies, you don't need a full penetration test every year. I think that's especially for financial advisors where for them, if you guys aren't familiar, financial advisors someone you go and talk to and they'll be you should invest your money in these funds and stuff. They typically don't have their own financial investment platforms. They're going to someone like Fidelity or wherever, and paying them, and Fidelity has all the systems and they just log into it. So a 4-person shop that's just running everything out of Fidelity, like they don't have a lot of their own systems to like go test and everything. So they still need to have a cybersecurity policy that they're managing and like reviewing, and how do we protect our systems? Because like I went to a company one time and they had like no policies. Like it was like bring your own device, but there were no security requirements for those own devices. Like they literally just joined it to like the Wi-Fi network. And so like they're like, if the SEC had come and done an investigation of them, and that was like 6 or 7 years ago, that lack of policy would have gotten them in a bunch of trouble. And they eventually did get in a little bit of trouble, but they remediated it, so it got fixed pretty quickly. But so that's probably that. How much you should be testing and what your assessment looks like as a small company are probably the most ambiguous part of the SEC guidance right now. But yeah, it mandates the disclosure of material events within 4 days of determination. So the important part of this is it's within 4 days of determination of a material event. So that means that there's also a little ambiguity on the reporting timeline of like when do you determine that something is an actual material event? Because just because someone, like a SOC alert gets generated in the SIEM, like doesn't, or an alert gets generated in your SIEM, doesn't mean that like you had a material event, right? And so like there's a lot of like, okay, which we'll go through in the case study in a second. So yeah, that's kind of all of that. The last case study we have before we do the tabletop exercise is just talking about SolarWinds. It had a really profound effect on what the SEC considered enforceable requirements. They went after the CISO. They tried to like pin a ton of stuff on the CISO directly. Pretty much all of it was dismissed by the courts eventually, like 2 years later. So they weren't quite successful in that, but they have shown an increasing willingness to go after CISOs if they think there was negligence by the company. They think that that's one of the better ways to force companies to start addressing this stuff more seriously. Because we still have issues with companies trying to hide breaches, even though they don't want to. Basically, they've determined, so like even, I'm forgetting how much SolarWinds was actually fined, but multiple downstream victims were hit, like Mimecast was one of the companies. And the SEC fine was like $1 million, which is a lot to us, but for the companies is really not that much. So the SEC is trying to get more aggressive in the fact, because basically what's happening is bigger companies are making the determination that they'd rather risk the SEC fine than disclose, because the SEC fine is less than the reputational hit to the company. And so like that's problematic for the SEC if they want to enforce stuff of like, hey, we have all these requirements to disclose and all that kind of stuff, but companies are ignoring it because it's like us, you know, if someone told you that the speeding fine for going too fast was like $5, you'd probably be like, screw it, I'm just going to risk it, right? Instead of, whereas if it's a couple $100, then maybe you make your calculus a little different. And so they're getting more aggressive in trying to go after individuals because they haven't been as successful as they want to be in the court of getting large awards. One of the things that is changing changing companies' analysis on this stuff is actually European enforcement for the larger companies. So Europe's been really aggressive in enforcing breach fines on companies, like hundreds of millions of dollars in fines. I think someone actually got hit with like, was it Google technically got hit with like, oh no, that was the Russian thing. But I think Google got hit with like almost $1 billion in fines from the SEC at one point. Yeah, technically, I can't remember if it was Google or Apple. I think technically one of them got hit with $1 trillion fine from Russia as trying to penalize U.S. companies for Russian sanctions, but it wasn't like a real thing. But the European one, the EU one was a real one because it was under the GDPR. So that's actually had a GDPR more than anything else has had a huge impact on how companies handle and disclose security events because the fines are so large coming out of the EU. So before we go into our tabletop exercise, does anyone have any questions on stuff? No? Okay. Okay, so we're gonna do like a tabletop exercise. I just made up some stuff. We're gonna pretend we're a small investment company with 200 employees. Oh, that was supposed to say investment. Oh, I apologize. So ignore the manufacturing, automobile, and aviation. We're going to be an investment company so that we actually have SEC guidance applied to us. Our annual revenue is like $42 million, based in St. Louis with a small satellite office in Illinois. We take on mostly retail customers through its financial advisement business, but there's some limited involvement in commercial real estate. So we have some larger customers. Like if anyone didn't know, but in St. Louis, we have the AT&T building. It's the largest it's the tallest abandoned building in the U.S. It's like 40 floors, and no one's lived it. No one's been in it for like 10 years. Our first event is like we come into work on Tuesday to find multiple reports of people having difficulty accessing their share drives. So like, what does anyone want to give me like what they think we should do as a company? Like, is there anything we should even do at this point? Like, we just know that people are saying that there's issues with the share drive.
I feel like at this point it would be something, because right now this could be like a number of things. I feel like it could be just like a network issue, maybe it's always DNS, so maybe, it's just...
Yeah, so right now, exactly. Right now, we don't know that anything actually happened. In fact, at this stage, security might not even have been contacted. People might just be assuming that IT did something wrong, broke the system, right? So IT might just be calling and being like, hey, everyone's calling and be like, hey, I can't access my SharePoint and I need to get my weekly staff meeting slides off of there. And that's kind of all that's going on. We at this point, we can't really make any determination. But let's say that for our next one, that our HR system supplier, so we're using like Workday or something like that, calls us and says that they have experienced a breach on their network. So now we have issues with our share drives, and we have had another supplier tell us that they've had a breach. Do you guys think that we are in a breach yet, or do you think that how would you guys handle this? Would you consider it an event? Because we have no data, we have no information that they've actually accessed our network yet. Yeah, you would at least be calling people, right? You'd at least be calling security to be like, hey, are you seeing any weird activity on the network? And so we still haven't experienced like a material event at this point. And so we would probably start going down the road of investigation and all that. Well, not probably. We'd definitely start going down the road of investigation because we got something anomalous on the network, and we've been told that a supplier has been impacted. But then we go to this one and say that people start having ransom notes. So now we've definitely got something going on right there. So we'd go and report this, and we'd start our reporting process. But what if we didn't get like ransom notes? What if we just started doing our investigation and initially we didn't find anything wrong, and then 3 months later, like someone found some firewall logs that said that someone had been in our network, but we don't have any evidence that any data was stolen. See, that's where it gets hard, right? Like,
I mean, if someone's gained unauthorized access, then that's a breach, right?
Not necessarily, not under the SEC guidance, yeah.
It'd be an incident, right?
Yeah, it'd be an incident, but you wouldn't necessarily have to disclose it. That's where the ambiguity is. Typically, until you see the way most companies operate now, until you have some kind of concrete evidence that data was exposed, then you'd most likely have something that you want to disclose. I know some companies have actually gotten more aggressive in their disclosure policies, as in they are more willing to disclose that a breach, like they'll call something a breach that doesn't necessarily reach the level of material because they'd rather be on the...
It's no longer shocking.
Right.
How many times a year do you get notified of a security breach? And everyone's like, eh.
Yeah, so especially if it's small, right? Like if you get a notification, nowadays you read like, they're like, oh, so-and-so got hacked and like 100 customers' data was exposed, and you're like, oh, who cares, right? Like it's, unless it's tens of thousands of people at least, like I'm not like, okay, they got 100 people exposed. So that is one of the interesting things about the material word we talked about, because what people are considering material, like the severity of the breach has risen for people to think that it's more of a problem, because there's so much expectation of cyber breaches nowadays that people react less negatively to breaches. So it's actually moved the bar a little bit.
Without categorizing it as material?
Yeah, you can always add something on your K8 form for disclosure and just say like, hey, we had a breach that was handled, and you don't have to describe it as a material breach. It's just not mandated that you report it. That's the difference. There's nothing, you basically put anything you want on a K8. You can say like someone, we had, yesterday we had 1,000 cases of someone trying to scan our external computers and put it on the K8. Yeah, like you can put it on there. And so that's interesting. Another interesting practice that I haven't seen the SEC make a rule on yet is some companies have started putting like, I mentioned that they have to disclose, that you now have to disclose your cybersecurity policies and practices. Some companies have started putting like a web link on the K8 that points to it, because like cybersecurity policies are like long, so they're not trying to put it on there, but it also means that they can kind of dynamically change the policy without changing their disclosure form, which is kind of like an interesting, so.
Also marketing too.
Maybe a little. I don't know how many investors are going and actually pulling the K8 forms besides cybersecurity professionals, but it's just more interesting. We haven't seen it yet where, but I'm sure it'll happen eventually, where a company doing that experiences a breach. Maybe they hadn't updated their documentation in 10 years, and somehow after they had a breach, but before the disclosure, all those documents are updated on their page. And the SEC doesn't necessarily have evidence that they did that because it's just a web link. So unless you had some cachet to show that the documents had changed, you can't really prove that the company had changed them. So yeah, it's really interesting how people are handling that. Some companies are still, the really big companies are still kind of erring more towards the like, we're not going to tell anyone unless we have to because the SEC fines aren't that big. Especially if it happens in the US and there's not EU customers involved. But smaller companies are going the other direction, where they're like, we're just going to disclose everything so that we won't get in trouble, because they don't really know where the SEC is going to say what's reasonable for them. Yeah.
The old adage was, maybe it's because I grew up in big places, but like nobody uses the B word except for the lawyers.
Yeah.
Only the lawyers can say that they breach. So
Yeah.
Is that still holding true? I mean, with all the SEC stuff, I only see my microcosm stuff.
I think it depends on where you go and what. I've seen a lot of variances depending on the legal department. So like big places tend to be more of like only like the CISO or someone way up in the company can make the determination that it was a breach versus an incident. But I've also been in a few places where the lawyers admit they're not the most well versed in like cybersecurity policy. Because like when I was at Boeing, like they have like a whole department of lawyers now that are just cybersecurity lawyers. Like that's their entire job, is cybersecurity policy and management with like SEC and FTC and all that kind of stuff. But at small companies, they may have counsel, but they don't necessarily have specialized counsel like that. So I think breach has gotten less scary. It used to be, so like this like terrifying word that meant you were going to be front page news for the next 2 weeks on the, especially if you're a company of any size. But like we said, that's not really the case anymore. You might make like, the 5th page of the newspaper now, especially if it wasn't like anything significant. So there's some changes in that, but yeah, generally calling it a breach because it is like the legal definition for SEC and triggers all that SEC compliance, generally is someone like the CISO has to be the one that makes that determination, and everything else is just an incident until that person has made the disclosure. But you definitely want to have a lot of conversations about that. Sorry, my computer's being a little weird. So post-event, now that we've had our breach, like what does the company need to do is kind of like also an interesting thing, because the SEC, I haven't seen any enforcement yet, but technically most people are saying now that post-breach, you should be doing a update of your documents because your risk has changed in the probability of occurrence. So they expect some kind of update to how you're assessing the risk of cybersecurity to your company. And so, like I said, I haven't seen anyone yet get like enforced by the SEC where they had like a breach and then they didn't update their risk and then another breach occurred and then they get pinged for it. But the general kind of sentiment and all the people I talk to is that post an event, you should at least show that you reviewed your documentation. You don't necessarily have to change it, but you need some kind of documented occurrence that you reviewed the policy to see if anything needed to change. Because they're basically saying that since you in fact had a, like if your documentation said we have, a 1 in 1,000 chance of a cybersecurity breach because we're not the target of the APTs and all that kind of stuff, and then you actually had a breach, that you need to evaluate is 1 in 1,000, like really your security posture. So the way forward and how we can kind of protect ourselves is kind of think about what the SEC's top priorities are. The biggest one is that they want it to be timely and transparent. They don't want to see companies saying like data may have been compromised or that a breach may have occurred. They want to see concrete language from companies detailing information that has been exposed. And so, like I said, that's going to cause a lot of tension with your public relations team. And so you really need to talk about how to manage that. But generally, when you're talking SEC compliance, the more information, the better. Basically, no one gets dinged for saying that the customer data was exposed by the SEC unless you had unless they determine that your security controls weren't adequate for your level of risk posture. They aren't going to ding you for saying that customer data was exposed versus may have been exposed. And if they determine that your security controls weren't sufficient, using the may language instead of the was language isn't going to save you, because they're going to go look at your security policies and all that kind of stuff and be like, hey, you were storing social security numbers on a web server that was exposed to the internet with a desencrypted password. That's not adequate. And so if they start the investigation and they find that, they're going to determine that is not adequate regardless of whether or not you were actually exposed. That's kind of what that First American one was talking about, right? Like someone called them and said, hey, we found this. And then they found out that the company knew about it, or at least someone in the company knew about it, and they fined him anyway. So the lack of exposure isn't necessarily going to save you. So using that kind of language, especially with the SEC, doesn't really buy you anything. Reporting structures are really important. That's another thing that the SEC really cares about, is they want to see concrete, detailed documentation on how you're supposed to handle reporting during an incident. And then they want to see robust GRC documentation. So they want to see what your policies are, like how often you're supposed to be doing tests and assessments, how often you're supposed to be reviewing your documentation. And they want to see that what has been written matches. So that's another thing that a few companies have gotten in trouble for, is that they had documented policies, but they weren't following the policies, and then they got dinged for that. So you really have to make sure you're following the written policies. So like if you say that you're having like biannual reviews instead of annual reviews, but you're not doing the biannual review, that will get you more in trouble than just doing annual reviews. So like that's something that you want to keep in mind. And then you have to update policies at least yearly. You also need to include education for employees on how to report processes. Training is becoming a part of your GRC compliance documentation. So that's something that I expect the SEC will start looking at more heavily, because that's what a lot of companies are using to mitigate both their risk for in their disclosures as well as in their insurance policies. So when you say that we're doing phishing training at least quarterly with our employees, they're going to want to start seeing more documentation on what that training actually looks like. Disclosure is a balancing act. So I keep talking about what the SEC wants to see, but that doesn't include what the repercussions are in the court of public opinion. So it is a balancing act. You don't necessarily want to go out and say everything's been hacked all the time, because then you can get a reputation. But it is something that we want to coordinate beforehand. And then we have to assess our processes, but assessment doesn't mean testing. So you'll see a lot of that on, if you go look up SEC guidance and compliance stuff from consulting firms, there's a lot of them trying to sell testing services saying that the SEC mandates that you do run like a red team test every year. And that's not really what the SEC is saying, at least in my opinion. I'm not a lawyer, so don't take that as like verbatim. But in my opinion, they're not really requiring annual red team testing, especially for smaller shops. But if you're on the financial advisor side, they just want to see some kind of assessment of like proof that your controls are in place. So yeah.
So outside of the financial assistance companies, like SOC 2, they'll say you need a vulnerability management program.
Correct.
And or more like
Yeah.
or pen test. Like you don't have to have an investigator in vulnerability management.
Yeah.
It's kind of the same thing for them.
Yeah, same type of thing. I think it's harder for like large companies to justify to the SEC that they're not doing testing, like actual hands-on testing of some kind. But they don't technically, the way the language is written, it's written as assessments, it's not written as testing. And so and it's all tied to policy disclosure. So, and like what your risk management programs look like. So I think, in my opinion, again, that you can make a good argument that vulnerability management and assessment of like your security controls, like someone going in and verifying that in your Active Directory, your policy lockouts are this and those kinds of things are sufficient for SEC compliance. I haven't seen any smaller companies get in trouble in their year, like when the SEC has come and assessed them yet for that. Because there is some understanding that, pen tests are really expensive. So there's some balance there. Well, there's that too. You show a red team that came in and just ran a Nessus scan doesn't really do much for you in terms of actual risk mitigation, right? So, yeah. So that's my whole presentation. I don't know if anyone has any questions. We're about 5 minutes early, so cool. Well, thanks for coming, guys. Yeah.